Welcome back, everybody, to webinar 4 of Irish Hospice Foundation's Advanced Care Planning series. This is Build Your Dream Team, Choosing Supporters to Help You Thrive. My name is Valerie Smith. I am the Public Engagement Lead at Irish Hospice Foundation, and I run Think Ahead, our Advanced Care Planning program. I'm joined today by Lisa Dunn, Information and Support Line Lead with Irish Hospice Foundation, who will be monitoring the chat and helping with hopefully no tech issues that arise. This is Think Ahead. You may have seen this image. If you've been attending these webinars, you've certainly seen this image. If you see around, Think Ahead is the Advanced Care Planning Program with a focus on advanced healthcare directives, though we have been diving into some other topics in this series. We're on webinar 4, which means webinars 1, 2, and 3 are now recorded. They're all available at this same link here. So if you scan to register, it will actually bring you to those recordings. They're available on YouTube. They're available on our Vimeo page. Webinar 4 will be recorded and available by the end of the week as well. These are also all transcribed, so hopefully a little bit more available to others as well. Feel free to share these. Feel free to send these around to anybody who may be interested. And they're there for you to go back in case we cover anything today that you need a little refresher from a past week. So here we are in webinar 4. Today we will be reviewing the role of supporters. We'll be looking particularly at designated healthcare representatives within advanced healthcare directives, and we'll be looking at the role of attorneys in the enduring power of attorney, as well as what are the next steps with that. The materials that you'll be using today are My Advanced Healthcare Directive, the EPA checklist, and yes, worksheet 7, not a question mark. I should have taken that out. Lisa is putting the link to that folder in the chat for you now. It should work. Quickly, we're going to review the first few webinars. If there's more questions that you have on these, I urge you to go back and review there. We've been looking at different types of advanced care planning available to us, future care planning, with particular focus on the Think Ahead Planning Pack. We've looked at My Personal Wishes and Care Plan. We've, this week and last week, been looking a lot at the Advanced Healthcare Directive. And this week we'll look more into enduring power of attorney, the property and affairs and the personal welfare, the types of decisions that you can make. And in the past few weeks, we've looked at how to get into that system and how to get our identities verified. In order to make these documents, you do need capacity. So that means that when you're making these documents, can you understand the choices in front of you, compare those different choices, choose one, make a decision around it, and explain that decision to somebody else. If you can do these things for an advanced healthcare directive around your treatment options, you have capacity to make one. For enduring power of attorney, it's the same idea. If you can understand the different options available to you, compare them, choose attorneys, choose decisions that you'd like to have looked after, and explain that and make that document, you have capacity to do so. We have more on capacity in previous webinars. We've looked at mainly at informal supporters, but a supporter is a person or people who are helping another person to think about their choices, to make those decisions. That's what we've looked at primarily before, and now it's about helping communicate and act on those decisions. If a person doesn't have capacity to do some or all of those activities, they can have formal or informal supporters to help them do so. We're looking at really formal support agreements that we can plan into the future, but there are support agreements available for people who need support now, but maybe not as much support as a healthcare directive or an EPA. So there are other options available. We're not covering those in this series. Primarily, we've been looking at gathering information, talking together, and technical support. How do we support someone to get into the services? And we'll be expanding on that today. So we're at step 4. How do we choose our supporters? I'm going to play this short video for you to start us off with a little bit of myth busting. So I'll start you here with the truth about next of kin. And Lisa, just let me know if the sound doesn't come through.
If, in the future, You're in a situation where you cannot make decisions about your medical treatment. You might assume that your next of kin will make those decisions for you. This is a widespread but incorrect belief. They can advise your doctors, but if they disagree, this can cause conflict and confusion. Family, even a spouse or children, are not automatically given the right to make medical decisions for you. To avoid this confusion, name a designated healthcare representative in your Advanced Healthcare Directive. Choose one or two people you trust to make these important decisions, if they are needed. They can be family, but they don't have to be. Talk to your designated healthcare representatives in advance and let them know your decisions and preferences. This way, you can feel confident that your wishes will still be followed.
So, next of kin, just going to go back here a little bit. Next of kin is an important concept that we are working to find new phrases for. It's really common, and in some legal proceedings, it is a term that's used, but it doesn't have legal standing for healthcare decisions or even for financial or property decisions. So, if you're looking to protect yourself into the future and make sure that what you want for yourself is decided by the people who you want to decide things, it's important to make these documents. Otherwise, somebody could step in who maybe doesn't have your best interests or who thinks they do, but disagrees maybe with how you would approach a subject. And in the end, a court can also step in and appoint somebody that they think is appropriate, be that a family member or from a professional panel, if you don't name someone and important decisions are needed. So this just gives you, naming people in these documents gives you the power to have your voice heard throughout your life in the way that you want it done. So we're not going to watch that video again, but we've looked at the Advanced Healthcare Directive. Last week, we were really looking at refusing treatments and consenting to treatments. Today, we'll be looking at that appointing a supporter piece. And as a reminder, we haven't talked about this in a little while. Within an enduring power of attorney, you can decide what you want looked after in terms of your property and affairs and your personal welfare, and who will be looking after that as well. Formal supporters can be named to look after all of these things, only if they're needed in the future as a backup plan. These can be the same people or different people. So even though there are different documents, there's the healthcare directive and an enduring power of attorney, they can be the same people in those documents, but they are different. We'll start then with those healthcare treatment decisions and the designated healthcare representative. This is coming off of last week, so you'd be nice and fresh with thinking about all the treatments that you would refuse, that you would consent to. And now you can do the third thing in this Advanced Healthcare Directive, which is name a designated healthcare representative. This is the fancy term for your healthcare decision supporter. In the Advanced Healthcare Directive, you can name one person and one replacement or backup person. That's called your alternate. They have to be over the age of 18, so an adult, and they have to have capacity as well. There can be no barring orders against you or your child for this person to be named. And this last one is a little confusing, but they can't be in a paid caring position and not be a family member. So if they work in the nursing home where you live into the future, and they're not related to you, that person could not be a designated healthcare representative. But if they work in the nursing home where you live and they are your niece, that person can be your designated healthcare representative, as long as they're a family member, if they're being paid to care for you. So family carers at home, all good. You don't need to worry about that. This is just making sure that anybody has a financial incentive to make any decisions about you wouldn't be making those decisions if they don't know you personally. But Generally speaking, otherwise, a healthcare representative does not have to be a family member. So it can be a friend, it can be a colleague, it can be, um, generally speaking, what they call a trusted person, a neighbor, anybody that you trust, and are able to have these conversations with. And sometimes that isn't the closest person to you. So it's just about looking around within your community and seeing who's willing to do that. So you can name one and you can name a backup person. What do they do? At the baseline, what they're always required to do is ensure compliance with what you've documented. That means if you have refused something, they make sure that your refusal is made known to the healthcare team. Um, if you consent to something, they can advocate for you to receive that treatment if it's appropriate. They can't make different decisions they can't make their own decisions. They just follow what you've put in there and make that known to others. They always refer back to the Advanced Healthcare Directive. But by ticking one or two extra boxes, you can give them additional roles. If you're looking at the Advanced Healthcare Directive, either on the computer or in front of you, this is on page 17 of that document. So they may advise and interpret your wishes. So in case there's any sort of gray area, they can advise, they would be the designated person to advise the healthcare team or interpret what they think you would want. And they can also, if you tick the box, give them consent and refusal to treatments based on those healthcare directives. So with reference back. So you can say something like, I would give my designated healthcare representative the right to consent and refuse to additional life-sustaining treatments, for example. This is what that document, it always has to refer back to the healthcare directive. So they can't be making up other things that they think you might want, but they may also document conversations that you've had or get clarity around things. And if they keep a record of that, that does act as known will and preference as well. So they can consent and refuse to additional treatments based on what you'd put in your documents. They can advise and interpret your wishes based on what you had written and your conversations. It always has to refer back to the healthcare directive. And so just to make that a little bit easier to see here, you can see that they're always ensuring compliance with the ensuring compliance with the healthcare directives, and they may advise and interpret if you tick this box, and they may consent or refuse if you tick this box. So you have alternatives to give them more roles and responsibilities. The signatures are an important part, of course, of this healthcare directive, whether or not you've named anybody as a designated healthcare representative, which you don't have to do, but you can. So at the minimum, you have to sign this document, and two witnesses must also sign this document. One of those witnesses has to be outside the family, but pro tip, a cousin is not considered an immediate family. And so there's a little loophole there in terms of getting people close to you together. So a cousin could be the second witness. But there's a whole list of them in the front of the Advanced Healthcare Directive on who is and is not considered an immediate family member. So you sign it and two witnesses. If you have designated a healthcare representative and a replacement or an alternate, they also have to sign it. Everybody has to sign it at the same time, and what's called in the presence of each other. And in the presence has been legally interpreted to mean in the physical same room as one another, and with the caveat that there isn't a place to mark where you're signing it in these documents, and they're really only looking into the details of this, apart from the signatures. If there's any concern around coercion, if they think somebody didn't make this voluntarily, that somebody made it for them or they were forced to make it. So if there's any sort of concern around that, the healthcare team will look for evidence that it is invalid. They have to show that evidence. But if everything's on the up and up, there shouldn't be any issue. Then same time and in the presence of each other, you sign this, and there shouldn't be anything to look into. Say that. Okay, so Everything's signed, whether or not you name someone, you sign this document, and then it's completed. With the Advanced Healthcare Directive, at the moment, there's no register for these. It could be in the future. I have a little daydream that it will be in the HSE app, if that works down the line. It may sit under the Decision Support Service into the future, but at present, there is no mandate for that from the legislation. We do advocate for it so that it's easily accessible, but the person making these documents and their healthcare representatives would be sharing these out in case anything happens for the future. So sharing out in advance of anything happening. I just want to say on this as well that the witnesses are not required to read the document. They don't need to know what's in there, but the healthcare representatives would have to know what they're agreeing to. So you read it and your healthcare representatives, and then you can share documents as needed. The big piece of today's discussion is around enduring power of attorney. So we've got a fresh term here, attorney. And an attorney is named in an enduring power of attorney, and they are one, two, or even more people. They're also over the age of 18. They also have capacity. They also may not have any barring orders against you or your child or children. They can't be an owner, provider of the facility where you live, similarly an employee, unless they're related to you. And there's a couple of other caveats here for enduring power of attorney. So they cannot be convicted of any offense that's relating to any type of decision support. So if they've been named in an enduring power of attorney before and they were not following those rules, they were pilfering a little bit of here and there for themselves, anything like that, they were convicted of something, they're not allowed to be named in a document into the future. If they're financially insolvent, so if they are in insolvency, going through insolvency, they are not allowed to look after your property and affairs. There could be some safeguarding issues there. However, they could still look after personal welfare, your day-to-day kind of care. So they'd just be barred from property and affairs. So a couple of extra caveats and protections there for who can be named an attorney. But you'll notice attorneys here, you can have one, two, or even more. In the healthcare directive, the people that you name there, there's one and a replacement. So it's really limited. Here you have more option to include more people. You'll have the EPA checklist in that pack. And I just want to show kind of something out here. When you're getting ready, the way that EPA puts this forward is asking first, who are your attorneys? How do they work together? And what kind of authority are you giving them? And then they ask what types of decisions do they have the power to make? That's one way of approaching it. We're going to approach it from the other way. So you'll see here I've highlighted kind of here's the types of decisions that they can make and so on. We're going to approach it from the other way. I'm going to show you what types of decisions you have the option of letting them have power if needed. So we'll look at these decisions first, and then we'll ask who would you like to name in those roles. I think it can help just to get an understanding of what you can really be asking someone to do before you decide who will do that. So, enduring power of attorney. They can look after your personal welfare and your property and affairs if you're not able to do so for yourself in the future. There's two types of what's called authority. We're going to go through this slowly, so don't worry too much about this right away. You can give two types of authority for each of those categories. General authority, they're responsible for everything under that category, or specified authority, some but not all of the decisions. So for personal welfare is the first category, and there'll be several kind of different options that fall under personal welfare, which we're going to go in through. And you could say they have general authority for everything under personal welfare, or they have specified authority for certain topics under that category. And the same for property and affairs. General authority for everything or specified by topic. This is what it looks like once you've gotten onto the website. So after you've made your account and you've had your ID verified, you have the chance then to make your documents, and you can make an enduring power of attorney. You put your information in there, and when you're at the decisions page, you'll have this option. What decision types would you like them to include? And you have these three types here: personal welfare, property and affairs, or both, highlighted in blue. And for each of those, you'll have what type of authority would you like to give them? General authority or specified authority? We'll go through that next. What does it mean? But just a fun fact, we are going to go into the weeds and the details here, but the number that I heard, and this was a few months ago, most EPA applications are giving general authority for all decisions. So while we are going to go into what that means, what types of decisions you may be giving somebody, you may decide in the end that you don't need to specify anything. And most people are saying, I'll give all authority for these decisions. It's the easiest way to do it, but everybody's might be slightly different. Although we're seeing most people's are kind of falling in this pattern. We'll start with personal welfare. So for personal welfare, you can include all, meaning general authority, or only some, which is specified authority, of these topics. You give the power of attorney for somebody for these topics. So accommodation, they are working to follow your will and preference on where you live and the state of that place. So that can include looking after the house and making sure it's safe enough to live in. Employment, full or part-time or volunteerism. If you'd like to do a bit of volunteer work, they can help with this and getting you to and from work and helping with applications and all sorts of things. Education and training, if there's schooling that you'd like to keep doing or keeping involved with. And participation in research. This is excluding medical trials, so this isn't about research on you, but your participation in research if you like to answer surveys and be involved in research maybe around illness or injury or aging or anything. Whoever you name as your attorneys here will be looking after your social activities, so your social life, making sure that you're engaged socially with others in the ways that feels right to you. Your social service and benefits, although with the exclusion here that applying for social services and social service benefits is in the other category. So you will see that there's overlap and there will need to be communication and partnership from anybody, different people if you name different people. Healthcare, and this is excluding treatment decisions, but they make sure you get to your appointments and are maintaining a level of health and well-being that's satisfying to you. And then other personal welfare as you see fit. And one of those, actually that falls under the other category. So you can add other topics in here, or you can specify other topics as well. So if you give general authority, they have the ability to do all of these things. And you may say that you'd like the people or person that you're naming to only do some of these things. And then you have the option to give more details or any exclusions. So even if I've given general authority to somebody for my personal welfare, I might decide to give a little bit more detail around my accommodation, where I would like to be living, or under what circumstances I would move perhaps in with a family member. If there's certain social activities that I like, certain types of healthcare appointments that I would never go to. I'd never go to acupuncture, so don't even try it. You can put those into here as well. So you can provide as much detail as you like, although you're not required to, but you can provide more detail as appropriate to you. And I'll give you an example in just a few slides. The second category of enduring power of attorney that you can give powers to is property and affairs. Property and affairs includes all, which is general authority, or some specified topics of the following. So it looks after property, and that can be property management, selling property, buying property, exercising the powers of tenant for life. So if somebody, you do give them the ability to sell your house, but you want to remain in your home for as long as possible, you can have them exercise those powers. You can give the role to an attorney to look after your business or your trade or your profession, as well as dissolving a partnership, a business partnership. Looking after and managing your taxes, your debts, and liabilities. That includes paying your bills, making sure that your finances are looked after. If you're involved in any court proceedings, applications for social services, which we discussed from the last time, not necessarily managing those benefits, but applying for them. Providing the needs of other people. So if you have dependents that are also looked after that may need additional supports, and that's a role that you do, they can support with that, and other properties and affairs. And I'm going to give you a good example that could be included in this one in just a moment here. Well, when we're starting, this is what the page will look like. So I said when we came in, the first thing that you'll do is put your own details in this 1A and the supporter details. We're coming back to these because we started here with arrangement decisions. And just ignore this red line. That's because I'm always generating documents in here for examples. So you come into your enduring power of attorney like we showed you on the last page there, and you can choose which decisions you would like to include and what type of authority you would like to give your attorneys, general or specific. So you have a choice for each of those. And then you move down to these decision types. When you click this button here, personal welfare decision, you'll see that you have the option to choose which would you like to give more details or exclusions for. So I've given an example here for accommodation. I would prefer to live in my family home for as long as possible. And under exclusions, I might write, unless it is unsafe for me to do so. But you can add as many details or exclusions as you like to give more information. And then you can go in and add another personal welfare decision, perhaps relating to healthcare or social services, and you can do the same for your property and affairs decisions. Another thing that you can do, and this is I'm very grateful to the Decision Support Service, member of their team who brought this to my attention, is that you can include gifts. There's not a subcategory or topic under property and affairs called gifts, but you can include it in sort of that other category. So gifting can be done in two ways. So you can you can include in your EPA that you want to gift to friends and family on sort of those customary occasions like a birthday or Christmas or weddings, anniversaries. And you can also gift to charities. So if you have always gifted every year a certain amount to a certain charity, maybe Irish Hospice Foundation, you can include that in your EPA as well, so that they continue those gifts in line with what's appropriate, but you can describe that in more detail. So to family and friends, you would say, would I like to give gifts to people on occasion? Would I like to specify a certain amount that they should spend on a gift? And should they be monetary gifts? Should I be giving somebody money, or should I be giving a physical gift? And what type of physical gift would I like to give? So you can think about these things for the people close to you and describe that to the attorneys. What I will say, it is important on this one, if you don't describe gifts in here, they might not be able to do that. And so might not be able to do that on your behalf. So if this is something that you'd like done for you, do include this as sort of that other document. And the same goes to charities. If you'd like anybody to make donations to charities on your behalf and a specified amount, which you do or don't have to include, you can detail that as well. So this is what we mean when we're saying if you want to describe the things that are important to you under these categories, these can be the types of details that you're including in there. I'm always very keen on describing details around accommodation. We all are, we think about that one a lot, accommodation, where we're going to be. And it can also be things like, would I like to live close to services, close to family members? Would I like to live in a place with lots of activities on? Would I like to live in a large residence or a small residence? These sorts of things. So you can really think about, even if I can't be at home anymore, what are the qualities of the place that I would like to be? So you can get a little creative, Don't need to worry, don't worry about it, but if there are things you know that you would like to include those. So this part is tough. This is how we make those decisions and how we choose who's going to look after these things. These terms I find difficult. I do understand them though. So my hope is that at the end of the next 15 minutes, you are going to understand these terms too. Um, there's three types of ways that you can name people to make decisions. So first we'll start with how many attorneys should I have, right? I can, in my advanced healthcare directive, it's really limited. I have one main and one replacement, but here you can have as many as you want. So some people might choose that they have one attorney. The pros of this being that there's one person who's kind of responsible for everything. There's no confusion around it. But it can be a lot of work for one person. Maybe it might be overwhelming or too much for one person to manage alone. And also there's the consideration of, well, what happens if that person is away or isn't available? So in some cases, you might want to have two or more attorneys. You might wish to share that work amongst people close to you. Pros of this, that you can define, who is what role, who's best to carry out or perform this decision, and maybe somebody else is best to carry out or perform another one. It can cause confusion if those roles aren't clearly defined, so we'll go into that after this. And it is important to consider that your attorneys should be able to work together. Of course, you can name who you want, and you may find that you're not able to find people who don't have conflict. It is just the way of it sometimes, especially when naming, family members and things. So, but ideally, if people are required to work together, that they will be able to work together. Otherwise, you may find that somebody steps back from the role, recuses themselves, or isn't able to perform well. And this has an effect on you in the end. So I know there is kind of this tendency of things that I hear that people are really concerned about who they name and not wanting to upset anybody, and so wanting everybody to have an equal say. And it is about your quality of life as well. Who's going to work well and do things for you? And not everybody wants these roles either. So just to think about that. And then you can have replacement attorneys. So you can have as many sort of main attorneys and as many replacement attorneys as you like. So, this could really support somebody if there's only one attorney, but that attorney has gone away. In some cases, you might name somebody who actually predeceases you and isn't able to carry out the role because they're no longer here or they step back from the role. Then you can have a replacement. And in the case of two or more attorneys, they can step in depending on how you decide. If one attorney isn't able to do the work, if one attorney is out of the country, if an attorney predeceases you, and you can say, first, I'd like this replacement, then this replacement, and so on. So it might be that you decide of the people close to you, two of them are the mains, and then two are replacements in case somebody's not available. So you can determine and define how and when you would like those people to step in. Okay. So the first way that people can work together, and what I'll be doing for these next few slides is acting as though there's more than one person who you've named as your attorney. And the first way that they can work together is jointly. Jointly means that they must work together on all those decisions. So I'll be using these four examples for these types of decisions. So around accommodation, this would mean that both of the attorneys that I've named have to work together and decide together where I'm living and the level of quality of where I'm living, whether that's my house and my house needs upgrades, they decide those together. Or whether I'm moving into a residence, they decide the residence together. So it can't be that one approves the cheapest residence because it's affordable, or another says, oh, we'll put over there because it's the nicest one, but it's far away. Whatever it might be, they have to come to an agreement together. Still, based on your will and preference, based on what you've detailed in there, but they have to make that decision together. And that could be if you've named if you've named two or three, or however many you've named as your main attorneys, they all have to make this decision together. For selling property, this would mean that one person doesn't have the role or responsibility of selling the property on their own. They're not allowed to sell the property without the agreement of the other person. Both people have to sign documents, and nothing can be done without the other's agreement and approval. Around gift giving, as you've detailed in your documents, this would make sure that both people are agreeing to the gifts being given and may work together to decide what the gifts will be, and maybe one person goes out and purchases those gifts with the approval of the other. And for social activities, this would be that the people you've named decide together what are the social activities, how are you going to get there, and probably coordinates the calendar fairly well together. So they work jointly and they have to work together for all of these decisions. A couple of things to think about with this style would be, do they work well together? You probably don't want to put two people working jointly if they have to make decisions together, if they don't work well together. They may need to live nearby to each other. That, you know, doesn't have to be that way, but if there are papers that need to be signed, if accommodation needs to be visited, that it's agreed between them how they might do that if they don't live nearby to each other. It can be tricky. I'll just say as a side note on this, appointing people who don't live in the country, it may be quite difficult for them to carry out some of the tasks. So just to think about having somebody who is in the country and can arrange either working with somebody outside of the country or will arrange to do the work that's necessary in the country. And then just to think about what happens if someone is away or unavailable. So if they're required to work jointly, but somebody is on holidays when a decision is needed, does that decision then have to wait until they're back? Is there a replacement who can step in, or will they always be, available to work? So just a few things to think about if you're deciding that they have to make all decisions together. The next way that they can make decisions is called severally. When I first heard this term, I thought the person had made a mistake in how they were speaking, and but this is the term, severally, as in several people. So they can work separately on all decisions. That's what I thought they were saying, separately. But severally means that whoever I've named a couple of people, and they don't have to make any decisions together. So that means maybe I've defined it as well. I would like this person to make my decisions around my accommodation. They've got a really good eye for things. And they're also a property manager, and so I've named them for selling property. And you can clarify within those details that you would like this person to do this thing and another person to do another piece. Perhaps around gift giving, you know that somebody is really good at that. Maybe person B is really good at that, so they can take over this. And then together, they'll maybe decide or maybe not together, but they'll decide kind of some social activities each. There could be issues that arise here if you're allowing people to do things separately without the other person's approval, where there could be disagreement, where there could be conflict. Even as an example of social activities, and both people not communicating with each other have booked, one's booked a dance class on Tuesday nights and another is booked men's shed on Tuesday nights. So even just deciding those sorts of things, if people work only severally, it could mean that there's too many cooks. So yeah, may cause conflict. So they should be well-defined roles. So if you're doing severally, just recommended to go in those details and describe who you would have look after certain things if there are certain things that really matter. The last option, and I think generally speaking, if people are naming multiple people in an advanced healthcare, or sorry, in an EPA, an enduring power of attorney, the jointly and severally, putting those two together as how people make decisions is also a popular option. So this is the third way that you can assign people to work together. So this would mean for each thing that I've put into the EPA, I have to describe, do they work together? Do they have to work together, or can they work separately? So I might say, I've given general authority over my personal welfare, but I still have to go into accommodation and describe, do these people have to work jointly together? So in this example, I've said, yes, person A and person B have to work jointly together on my accommodation. They have to make agreements together. But person A can be responsible for managing my property or selling my property because they're very good at real estate, whatever. Whereas I would like person A and person B to work together on gift giving so that there's no hard feelings, so that nobody thinks that somebody's getting a better gift than somebody else. So I've assigned them to work together on this. But person B is actually very good at helping me find social activities and takes me to a lot of my social activities now. So I'll say person B can work separately and do my social activities. You could also say any other kind of combination here. Maybe you want anybody to be able to make social activities for you, but they don't have to do it together. So you can name and get as detailed as you want within this. If there are certain things you do want people to work together on, and other things you say, it's fine, they can do that on their own. It's entirely up to you. So the biggest question for this one is just defining when and how they must work together. Okay. So I know that that's a lot of different options. Just going to run through them very quickly, that you can have as many attorneys as you like, from 1 to 100. And you can have replacement attorneys as many as you like as well. You just have to describe when they come when they come in. They can work together on everything. They can work separately on everything. Or they can work together on some things and separately on other things. Entirely up to you. And you could say you don't even have to define, for example, social activities is only this person. You could say either one of them could plan my social activities. So it's really up to you how you want to approach the people in your own life, how they work together, and what will be sort of for you and the best decision for you. In terms of paying your supporters, can you do it? Not for designated healthcare representatives. This could cause a conflict of interest. So designated healthcare representatives around your healthcare treatment decisions, they cannot be paid for their role. However, your attorneys can be paid. So you can decide how much they're paid and how often, if there's anything that in particular that they get paid for, if there's any exclusions. And that could be, anything from an hourly, I'd like to pay them €10 an hour but max 10 hours a month for their work. Or I'd like to pay them €500 a year for their work, or I don't want to pay them anything. So you can determine if you'd like to pay your attorney. So it may be that your designated healthcare representative is also your personal welfare attorney, or looking after healthcare decisions or healthcare supporting your healthcare in an enduring power of attorney, and maybe they're paid for that even though they're not paid as a healthcare representative. So you can really clarify here if that is something that you want them to have or not. So with all of this information, you are ready to write your enduring power of attorney. You have the people, you'll be thinking about the people that you want to name and the decisions that you want them to have that power of. Once you've made those drafts, and that's as simple as going through the video that I showed you where you name what the decisions are you want them to have, what type of authority you want them to have, and then those details, if there's any details or exclusions around that, and how you want them to work together. Once that's completed, you press the next button, you press generate documents, and it creates a bunch of documents for you. The first few being ones that you, your attorneys, and 2 witnesses have to sign together. Those witnesses are the same. One must be outside of the immediate family, and same here, cousins are outside the immediate family. So a nice kind of workaround there. You all sign this at the same time in the presence of one another. And after signing, then you have 3 months to get these other 2 documents completed. These are the capacity statements. One's from a medical professional, and there's a short list of different types. It doesn't have to be your GP or a consultant. It can be a nurse practitioner. There's a physical therapist, I believe. there's a list. So, there's a few different people that you can go and get a medical statement from, and they say, yep, this person understands what they're making and they have the mental capacity to do so, and a legal statement from a solicitor or a barrister who also ensures that you have the capacity of understanding that you're making a legal document around these. We don't have, there's no control over what these different documents cost, so shop around a little bit. We think medical statement is about 100 to 200 euro. The legal statement could be, there's a really wide range of even who will complete them. So hopefully that number is becoming more affordable, but call around. Lots of places are doing them. But it's 30 euro to register your enduring power of attorney. We've got those kind of legal costs there. And once you've gotten those signatures, you upload everything back to the same file. Uploading is a support that people may need, and so sort of an informal support that people can provide to help people with their tech support on the decision support service. So they upload these, and then the DSS will give you some documents. This is called notifying. So you just have to notify all your certain people, all your children, spouses, anybody that you live with, that you've made this document. And that gives people a few months to review and to raise a complaint or concern if there is one. This is a protector for you so that somebody else can't say that you've done this and say that you've done this and somebody else says, wait a minute, I don't think she actually did make that, so they can raise a complaint, which is investigated. So there's 3 months for people to review and raise that complaint. And then the EPA is registered and it sits in the system until it's needed. If it is needed, then whoever you've named as the attorney, it's their job to notify the DSS. If there's no complaints around it, they notify everybody. It's enacted and people can use it. So this kind of part here does involve probably a little bit more than we have time for today, because we really just wanted to focus on who do you name in these documents. And so for that, you do have a little bit of homework this week, should you choose to accept it. In that file, again, you have worksheet 6, and this has a few different documents, just thinking about who are these people that I want to name. So if this is something that you're struggling with, it allows you or kind of guides you to give a few people's names of who you think might be a good person to name in these documents, and which of these jobs roles would you want them to have? And for the EPA enduring power of attorney, would you want them to work together or separately or severally or together and separately? So you can just kind of use this as your tracker, and you might see at the end of it, oh, you know what? I've named person A for every single item under personal welfare. So they'd be a great person to name for personal welfare. And maybe I've named person C for most of my property and affairs. So maybe I'll name them. So it can just help you kind of view who you would like to name in these documents and maybe how you'd like to name them. So just to get you started there. You probably have a lot of questions on this. I'll direct you to the decision support service, the free phone service there, 01-211-9750, and then you press 1 for the EPA helpline. And I will let you know, I got some good feedback from an attendee recently who has been advocating for all of this in her communities, and she did say somebody had tried the decision support service several months ago and had a really hard time, and at this attendee's urging, she went back and called again, and she said it was so much easier this time. So services are continuing to improve there, and we've got a testimonial to that. So do contact the decision support service, and they can go through these in detail with you around any questions that you might have around what types, how do I want people to work together, or can I name this person? And they can go through all of that with you. We have the information and support line that can guide you around the basics of these things, although, not giving clinical or legal advice here, but that number again is 1800 60 70 66 or support@hospicefoundation.ie. And of course, you have the documents of Think Ahead, but you can always download them with a QR code on your left, or you can order online on your right, or you can call us to order over the phone as well. We do have at costs for many HSC departments and nursing homes, and so if you email us, we can send you the form to complete for us to generate a quote or an invoice for you. Our contact information is here, so please reach out with questions. We'll hopefully be coming back to you with a survey on what you would like to see more of, what you didn't learn well, what was incomplete, what was great, so that we can carry on these webinars. To leave this with you, I'll end the recording here, and thank you to everybody who's watching on the recording. And for those of you watching live, I'll be back with you in just a second.